Namaskar, Adab, Sat Sri Akal, and a big hello to each one of you. In our series Legal Literacy for Everyone, today's topic is a very important one. We are going to discuss cases related to the checks that are bounced and that make the parties go to court and raise litigation. To begin with, I would like to share that calling a check getting bounced is not the right way to describe it. Actually, it is the dishonouring of the checks, which I think, in our discussion forward, this is the term that we are going to use. In the year 2008, the Law Commission of India came out with its 213th report, wherein it made a very, very serious observation. It said that more than 40 lakh cases of situations wherein the checks were dishonoured by the banks and that led to the litigation are pending in various courts. And although the figure of 40 lakhs looks enormous, but when seen in terms of how much it contributes to the overall pendency, this segment of pendency actually becomes probably a big menace for the Indian judicial system. At present, as we all know, there is a pendency of about 4.8 crore cases in various Indian courts. And if we go by what the Law Commission of India said about 14 years back, these cases, which is the check dishonoured cases, they constitute about 15% of the total pendency of the criminal litigation in India and 7.5% of the overall litigation in our various courts. And this therefore sounds very serious and needs to be looked at very, very seriously. Now, what is meant by a check getting dishonoured? But before that, let me give you a very, very brief idea about how this act, which is known as the Negotiable Instruments Act 1881, how this act came into being. As we all know, way before the British came to India, India was known for its trade and commerce. And much before their arrival, India was quite accustomed to the system of hundis, etc. Now, these hundis were nothing but the predecessor of the present check system. When the British came to India, they actually saw the trade and commerce increasing manifold, and therefore they were constrained to come out with a legislation which was titled Negotiable Instruments Act 1881. And the check that we are actually discussing today is nothing but an instrument of exchange which has been described in section 6 of this Negotiable Instruments Act 1881. Now, going further, how does a check gets dishonoured? It's a very simple case wherein there are two parties and one party is under an obligation because of a debt or a liability to make payment to the other party. It issues a check. Issuing a check is known as some drawer issuing a check. It goes to the payee, the person who receives it. He lodges it in the bank and the bank does not clear it with the remark that there are insufficient funds in the account of the drawer, and therefore now the payee, having not received the payment, becomes alarmed, disappointed, and starts a litigation under Negotiable Instrument Act. I would also like to bring to your notice that the check dishonouring was only a civil offence for more than 107 years, and it was in 1988 that the check dishonouring became a criminal offence, and sections 138 to section 142 were actually introduced into this Negotiable Instruments Act 1881, which made check dishonouring a criminal offence. So you would be curious to know as to how these cases were dealt before that. It was a civil liability, and in extraordinary cases, somebody could also go for an FIR under section 406 of the IPC for criminal breach of trust, or 420 for the offence of cheating, again under IPC. The other modes available were the alternative dispute resolution mechanism like mediation or conciliation or arbitration, or a civil suit in a civil court. And it would also be pertinent to mention that even in present times, an action under section 138 of the Negotiable Instruments Act, which I am going to describe a little later, and a civil suit, they could both be lodged parallelly. Now, coming to the Negotiable Instruments Act 1881 and how an action could be initiated, the conditions which are required for initiating an act, a litigation under section 138 of the Negotiable Instruments Act are: one, as I mentioned, there are two parties. A check issued by the drawer has not been cleared by the bank within 30 days of this bank giving this dishonouring of check memo to the payee. He is supposed to notify the drawer that the check has not been cleared, kindly make the payment. If within these 15 days the drawer makes the payment, then the matter ends then and there. But if in case he doesn't do it, then in the next 30 days this payee has to move a magistrate's court for action under with a complaint for initiating action under section 138 Negotiable Instruments Act 1881. Now, what are the documents which are essential for starting such a litigation? It's a very simple litigation, and the only few requirements are: the complainant has to show to the court that a due notice was served on the drawer when the check was dishonoured in the first instance. He should also furnish proofs of this servicing of the notice, which could be the courier's receipt or the receipt issued by the Indian postal authorities. Other than that, he has to show the original check which he has received actually from the bank, along with the memo that the bank gives in terms of when this check was dishonoured and the grounds why it was dishonoured. And in addition to this, the complainant has also to furnish the evidence for having some debt or legal liability, which means the drawer having or being under an obligation to make a payment to the payee. Now, these are the only few requirements. Now, in order to give strength to this 138 section, which principally, by making it a criminal offense, it was in order to give eminence to the check system, but it was further reinforced. It was further reinforced by bringing in section 143A in the year 2018, wherein it was said that during the litigation of during the pendency of the litigation under section 138 of Negotiable Instruments Act, the court, if it finds appropriate, can also order interim relief to the payee, and this interim relief could be to the extent of 20% of the check amount. So this was a big relief, and it was actually brought in to give some relief to the payee during the time. As we have discussed, there is a huge pendency, so we are going to also discuss how much time an average case takes. But this strengthening actually helped in the sense that in the interim period there is some relief. And even in cases where the trial court has decided in favor of the payee, there is an appeal by the drawer in the appellate court. The appellate court can also release some interim benefits, and this interim relief again could be 20% of the amount which was actually declared by the in favor of the payee by the trial court. So these were the efforts to strengthen it. Now we come to the most important aspect in terms of why such delay gets caused in cases of such a least complicated litigation that we have already discussed. In the year 2020, the then Chief Justice of India, Justice Bobde, took a suo motu cognizance of this fact while he was actually hearing another case, and he was actually so much disappointed when he said that there are more than 35 lakh cases of check dishonoured situations pending in various courts, and as per him there were 3 to 4 very important reasons why such pendency happens. Now, as per Justice Bobde, the most important reason was that the servicing of the summons to the party, the other party, which is the drawer, it takes, in many cases it takes more than 2 years. And he says that, and he said that this was the basic stumbling block in terms of why these cases don't move fast. Other than that, he said the courts in many cases actually were in a confused state of situation wherein it was not clear whether a preliminary inquiry at the level of the magistrate was necessary before starting the summoning process. Similarly, the conversion of a summary trial into a summons trial again was actually a stumbling block, in the sense that some courts took a different route and the others an entirely different route. And the fourth most important reason was that there were various cases pending against the same party in various courts, but there was no system of clubbing such cases. So, keeping this in mind, I think it becomes very clear that the basic reason for this malaise that we have already discussed of the cheque dishonouring cases making for about 15% of the criminal litigation in India and 7.5% of the total, I think this needs an immediate redressal. And the way forward, in my opinion, and which has been raised by many authorities and many theoreticians also, is that number one, at the judicial front, the judiciary has to open fast track courts, specific courts which are dedicated to this kind of litigation. For the legislature and executive, my suggestion would be that we have to now get into an era of discouraging the cheque issuance system. There are 20 countries out of 27 EU countries where the cheque system is almost become obsolete, and there is a norm of maximum 2 cheques that could be issued by a party in a year. Now, another step that can be taken is for the banks to make sure that the cheque dishonouring incidents should lead to a lot of punishment to the account holders. Even now, we find that we have a fine of say 200 or 300 or 500 depending upon the amount on the cheque that gets dishonoured. But going forward, this needs to be curbed by introducing greater fines. And one wonders why in India, where we have now the most ambitious project like Digital India and all, and we have now migrated to the NEFT and RTGS system of payments, why can't we stop this check environment, in the sense that, and it's a suggestion from our side, for example, for all payments say up to 25,000, let there be a check issuance system, and for any payment beyond 25,000, let it be only through the RTGS or NEFT routes. That probably can lead to a lot of improvement. In the end, there is a discussion going on in terms of whether criminalizing cheque dishonouring was a good step or not, or there are others who say that we should fast decriminalize this cheque dishonouring offences. There are opinions on both sides. Those who say that criminalization has not helped, they look at the pendency that is actually becoming bigger by the day, and they are normally saying that because of the delays being caused in the criminal litigation, the litigants are actually they are helpless, because on the civil side, because of this delay, the law of limitation beyond a point does not permit them to even go for a civil remedy. On the other hand, there are people who are saying that if we decriminalize, there are unscrupulous elements in our system who might try to take advantage of the fact that they could issue post-dated checks and then take the whole market for a ride. But again, I'm saying good vision has to be there. The Supreme Court has made it important in last few judgments. The legislature and the executive has also to rise to the occasion, and we have to together fight this menace. In the end, I would like to say that even one case of cheque dishonouring means somebody has transgressed the limits of ethics and morality, that our legacy has always guided us. So therefore it becomes pertinent that the legislature, the executive and the judiciary takes it up in the right earnest, and with with various efforts done in unison, this menace is checked before it becomes very, very difficult and before it actually damages our economy. We'll keep on coming with such important topics in the weeks to come. Keep supporting us, keep spreading such videos. Take care. All the very best. Namaskar.